Hello everyone, I'm Dr. Devdatta Das, Assistant Professor of Law from Department of Law, Bardhaman University, West Bengal. Today I shall deal with the topic Criminal Justice Administration and Vulnerable in the Society. The word vulnerable contains the Latin word vulnerare and abilities. It means able to be wounded. It relates to all such people or victims who have experienced an invasion into the self with emotional, physical, and/or financial damage. In the words of Kirchhoff, if victims were not vulnerable, they were not victims. Vulnerability carries with it an element of risk. The vulnerable victims was developed by Niels Christie, the Norwegian sociologist. There are two aspects of victim being victimized and associated with the criminal justice system. First, if the victim is subject to violation of his rights and approaches the criminal justice system for justice. Second, when the victim in course of interaction with the criminal justice system faces victimization. In every case, the potentiality of being victimized increases due to the element of vulnerability. People with impaired decision-making capacity are among the most vulnerable within our community. Such people are unlikely to be aware of criminal justice services, how to access them, and may be unable to assist a police investigation or suffer from insufficient financial or emotional resources. At times, such vulnerable victims do not even realize that a crime has been committed against them. As a result, as observed by Howard and Bryan, such persons are at greater risk than the others. In the opinion of Newbern, cases of domestic violence, sexual offences, and child abuse particularly brought vulnerable victims under spotlight. Due to various socio-economic and physical causes, such groups of people face limitations and are unable to protect and preserve themselves. Such kind of vulnerable groups who face discrimination and disability include women, children, elderly, scheduled castes, scheduled tribes, disabled, internally displaced and disaster victims, minority groups, and weaker sections of the society. Women. Generally, female victimization is considered to be restricted to sex-related offences. But this narrow observation causes gross mistreatment to the victims who are in more than one occasion subject to victimization on grounds apart from sex. The discrimination that a woman is subject to at her workplace, in her professional growth, the disparity in wages that she suffers, the ill treatment done to women in homes behind closed doors are not manifestations of sexual offences always, but are definitely quite vocal about the vast range of victimizations of various nature to which she is subject. It majorly reflects the power imbalance in a patriarchal society. The male superiority and insecurity gets reflected in such kinds of victimization in every field of human life, which ultimately calls for a special treatment and protection for women. The Dowry Prohibition Act 1961, Immoral Traffic Prevention Act 1986, the Preconception and Prenatal Diagnostic Techniques Prohibition of Sex Selection Act 1994 are few such legislations which aim at curbing various social vices like dowry, trafficking, declining sex ratio. All these laws ultimately aim at protecting and respecting the rights of women and womanhood. The Protection of Women from Domestic Violence Act 2005 was enacted for the protection of women from being victims of domestic violence. This law has addressed all sorts of abuses against women within the household, that is, physical, psychological, sexual, and economic. It has provisions which speak of various relief measures to such victims like monetary relief, protection orders, residence orders, conduct in-camera proceedings, etc. Some of the features of the Protection of Women from Domestic Violence Act are as follows. It is primarily a civil law for protection of women. However, the Act also provides that a breach of an order obtained under the Act is a criminal offence. It guarantees the women to following rights: protection from aid or commission of violence against her within and outside the home, communication with the woman, taking away her assets and or intimidation against her family and those assisting her, right to residence in the shared household. Next, it entitles the woman to monetary relief and maintenance, including loss of earning, medical expenses, and damage to property. It entitles to damages for mental and physical injury. The court can grant interim, temporary or ex parte orders in cases like custody of children, etc. The Act also entitles women to free legal services under the Legal Services Authorities Act 1987. The Vimla-ban Ajit versus Vatslaban 2008 case, the apex court stated that the Act provides for a higher right for the wife. She not only has the right to be maintained but also acquires a right to residence, which is a higher right. In Jovita Olga Ignacia versus Ranjan Maria 2011, it was stated that the expression domestic violence has a very wide amplitude and it includes physical abuse, sexual abuse, verbal and emotional abuse, economic abuse, which in turn inter alia includes deprivation of all or any economic or financial resources to which the aggrieved person is entitled under any law or custom, whether payable under the order of a court or otherwise, or which the aggrieved person requires out of necessity, including but not limited to household necessities for the aggrieved person and her children, if any. The Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 confers upon women the right to protection against sexual harassment along with ensuring their right to livelihood. It also addresses the issue of prevention and redressal of complaints related to sexual harassment at workplace. The guidelines laid down by the Supreme Court in Vishakha versus State of Rajasthan 1997 judgment were the first initiative which addressed the issue in conformity with the international standards as stipulated in Convention on the Elimination of All Forms of Discrimination Against Women, that is CEDAW, in 1979. Some of the distinguishing features of the law are as follows. The Act brings within its ambit a vast category of employees which includes regular, temporary, ad hoc, contractual worker, trainee, probationer, etc. The term workplace is also defined very elaborately and includes all departments, undertakings, establishments, organizations, enterprises, institutions, offices, branches. It includes both public and private sector, whether organized and unorganized. The Act provides for Internal Complaints Committee and Local Complaints Committee. Internal Complaints Committee is to be constituted by every employer in every administrative units or offices, and the Local Complaints Committee is to be set up by appropriate governments at district levels to receive complaints of sexual harassment from the establishments which do not have an internal complaints committee on account of having less than 10 workers. The victim is required to make a complaint to either of the two committees within 3 months of the incident, and subsequently the relevant committee can forward the prima facie case to the police under section 509 IPC. In case the allegation is proved, the internal committee or the local committee will recommend to the employer the appropriate action to be taken against the respondent for sexual harassment as a misconduct in accordance with the provisions of the service rules, or deduct from the salary or wages of the accused such amount as it may consider appropriate in order to compensate the victim. The employer is to take action within 60 days of the receipt of the recommendation. Factors like mental distress, capacity of the accused to pay, medical expense, etc. shall be considered while determining the quantity of the compensation. However, in case of a false complaint, the woman too can be subject to action in accordance with service rules or as per the recommendation of the relevant committee. Other relevant laws on this aspect are the Indecent Representation of Women Prohibition Act 1987 and Section 67 of the Information Technology Act 2000. The Indian Penal Code has numerous provisions which try to combat various kinds of offences committed against women. A quick glance through these provisions. Section 375 to 377 deal with rape, custodial rape, unnatural offences. Section 359 to 373 deal with kidnapping and abduction. Section 304B deals with dowry death. 509 and 354 deals with words and gestures or acts intended to insult the modesty of a woman. Section 354A and B deals with sexual harassment. Section 366B deals with importation of girls up to 21 years. Section 498A deals with matrimonial cruelty. Section 354C deals with voyeurism. 354D deals with stalking. Now, children. Children are supposed to be the most vulnerable section of the society. They get subject to various types of victimization in the form of physical abuse, sexual abuse, economic exploitation, etc. Some of the chronic concerns of the society centering child exploitation are child labor, child trafficking, child rape, child marriage, and many more. Let us discuss some of the laws dealing with children. The Juvenile Justice Care and Protection of Children Act 2000, the primary ambition of which was to create for children within the criminal justice system a child-friendly environment which will always work keeping in mind the best interest of the child and primarily focus on the reformation and rehabilitation of child in need of care and protection rather than victimize the child in the course of criminal justice administration, has been repealed by the Juvenile Justice Care and Protection of Children Act 2015, which came into effect from 16th day of January 2016. The highlights of the JJ Act 2015 are: the word juvenile is substituted with the word child throughout the Act. Special provisions for heinous offences, that is offences which are punishable with imprisonment of 7 years or more committed by children above the age of 16 years have been included. Juvenile justice boards and child welfare committees to be set up in every district. The Juvenile Justice Board is given the option to transfer cases of heinous offences by such children to a children's court or court of session after conducting preliminary assessment. The provisions provide for placing children in a place of safety both during and after the trial till they attain the age of 21 years, after which an evaluation of the child shall be conducted by the children's court. After the evaluation, the child is either released on probation, and if the child is not reformed, then the child will be sent to a jail for remaining term. The law will act as a deterrent for child offenders committing heinous offences such as rape and murder, and will protect the rights of the victim. Central Adoption Resource Authority (CARA) has been elevated to the status of a statutory body. Provisions related to adoption have been made more detailed and stringent. Numerous rehabilitation and social reintegration measures have been laid out for children in conflict with law and in need of care and protection. several new offences like sale and procurement of children for any purpose, including illegal adoption, corporal punishment in child care institutions, use of child by militant groups, offences against disabled children, and kidnapping and abduction of children which were not adequately penalized in other laws have been brought within the ambit of the new legislation. The Prohibition of Child Marriage Act 2006. The Child Marriage Restraint Act 1929 tried to restrain solemnization of child marriages instead of preventing or prohibiting it. The Prohibition of Child Marriage Act 2006 is enacted with the object to prevent child marriage, making solemnization of child marriage a non-bailable and a cognizable offence. According to this act, child marriage, that is bride being below 18 and groom being below 21 years of age, shall be declared to be void at the desire of either the bride or the groom. It provides clear provisions for providing maintenance to the bride by the groom or his parents or guardian until the court pronounces the decree. It also provides for the custody and maintenance of children which may have been born out of such a child marriage. At the time of granting nullity to marriage, the court can order for the return of the gifts and ornaments received at the time of marriage. It has strict penal provisions in case of an adult male marrying a child and for persons performing a betting, promoting, attending, etc. a child marriage. It declares child marriages to be automatically void in cases like the minor being is sold for the purpose of marriage, minor after being married is sold for or trafficked or used for immoral purposes, etc. The court has been bestowed with the power to grant injunction to prevent child marriages. The Protection of Children from Sexual Offences Act 2012. It aims to protect sexual victimization of children. Prior the enactment of this act, issues concerning sexual offences against children was taken care of primarily by IPC, and there was no distinction between such offences being committed against children and adults. Some of the salient features of this act are as follows. It protects children from offences which are in nature of sexual assault, sexual harassment, and pornography. The Act has made an elaborate categorization of various degrees of sexual assault on children. They are penetrative sexual assault, aggravated penetrative sexual assault, aggravated sexual assault, sexual harassment of the child, use of child for pornographic purposes. Act provides that in appropriate cases, the special court may, in addition to the punishment, direct payment of compensation to the child for any physical or mental trauma caused to him or for immediate rehabilitation of such child. The Act adopts a child-friendly approach and the best interest principle. In-camera trial, no detention of the child in police custody at night, medical examination of a girl child to be conducted by a woman doctor, and such examination in case of any child to be conducted in presence of their parents or any person in whom the child has trust, are some other features. The next category of vulnerables are the elderly. The obligation of the government to protect the human rights of the elders and to ensure them the highest possible standard of health, dignity of life, free from neglect and all types of physical and mental abuse has been echoed in the United Nations commitment in the UN Charter and International Bill of Human Rights, Universal Declaration of Human Rights, International Covenant on Economic, Social and Cultural Rights, International Covenant on Civil and Political Rights, Convention on Elimination of all forms of discrimination against women, as well as in Vienna and Madrid Plan of Action in 1982 and 2002 respectively. India in 2007 has brought into light a central legislation for maintenance, welfare and care of the elderly by their children. The Maintenance and Welfare of Parents and Senior Citizens Act 2007 aims to ensure maintenance and welfare of parents and senior citizens. It upholds the basic principles guaranteed and recognized under the Indian Constitution. Section 125 of the Criminal Procedure Code 1973 also makes it obligatory for a person who has sufficient means to maintain his parents who are unable to maintain themselves. The most striking feature of the Act is to make the maintenance of parents by their family a matter of legal obligation. The Act mainly focuses on maintenance, care and protection of the senior citizens by setting up tribunals in every district. The tribunal is required to ensure payment of maintenance by the children to the elderly parents and senior citizens. It also deals with complaints of neglect, physical injury, mental cruelty, desertion or separation from family and its restoration. The next category, Scheduled Castes, Scheduled Tribes. The Scheduled Castes and Scheduled Tribes Prevention of Atrocities Act 1989 tries to prevent the offences leading to atrocities committed against the scheduled castes and the scheduled tribes. It provides for special courts for conducting such trial, for the grant of relief and rehabilitation of the victims of such offences and other matters related to such issue. Internally displaced and disaster victims. Supreme Court, while discussing the issue of compensation to the displaced victims, had said that rehabilitation does not only concern about providing food, clothes and shelter, but also includes extension of support to help such victims rebuild their livelihood. It was said to be a corollary to Article 21, that's said in Narmada Bachao Andolan versus Union of India 2000. Severe public concern on land acquisition issues and absence of a national law to provide for the rehabilitation, resettlement and compensation for loss of livelihood of those who are dependent on the land being acquired for facilitating land acquisition, for industrialization, infrastructure development and urbanization caused the coming into existence of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. The rehabilitation and resettlement provisions under this Act come into operation when, first, the government acquires land for its own use, hold and control. Government acquires land with the ultimate purpose to transfer it to the use of private companies for stated public purpose, and government acquires land for public-private partnership projects. The Government of India, through Disaster Management Act enacted in 2005, tried to create a necessary institutional mechanism for monitoring and implementing disaster management plans. The Act provides for setting up of a National Disaster Management Authority (NDMA), State Disaster Management Authority (SDMAs), District Disaster Management Authorities (DDMAs). The Act further provides for different executive committees at national and state levels, National Institute of Disaster Management (NIDM) and National Disaster Response Force (NDRF). The Act further contains the provisions for financial mechanisms such as creation of funds for response, National Disaster Mitigation Fund and similar funds at the state and district levels. However, the law does not recognize legal rights of the victim to claim compensation. Disability. The Persons with Disabilities Equal Opportunities Protection of Rights and Full Participation Act 1995 defines persons with disability as a person suffering from not less than 40% of any disability as certified by a medical authority. Further, Section 2, subsection L of the Act explains the meaning of, under Section 2 of the Act explaining the meaning of disability, it includes blindness, low vision, leprosy, cured hearing impairment, locomotor disability, mental retardation, mental illness within the concept of disability. Risk of being victimized is much higher for people suffering with disability when compared with others. Disabled women, children, elderly people, especially if they are not financially secure, are subject to maltreatment and harassment. Ratification of the UN Convention on the Rights of Persons with Disabilities makes it obligatory for India to create an environment where people with disability can enjoy a status of a normal individual, enjoying their basic human rights, including legal rights, moral rights, etc. The Act aims to define responsibility of the state towards the prevention of disabilities, protection of rights, provision of medical care, education, training, employment, and rehabilitation of persons with disabilities. To create a barrier-free environment to counteract any situation of abuse and exploitation of persons, and to make special provisions for the interaction of disabled persons into the society. However, the statute is subject to some of the following criticisms. It is not a right-based legislation. The Act fails to impose mandatory obligation on the appropriate government and leaves the realization of opportunities to the discretion of the various state governments. The rights for the disabled women and children provided in the Convention for Full and Equal Enjoyment of Human Rights are rights like right to privacy, reproductive rights, right to family, health care, prohibition of discrimination and on grounds of disability in employment, political rights like right to vote and contest, etc., are not adequately provided in the Act. The term disabilities is narrowly defined and includes only blindness, low vision, leprosy cured, hearing, impairment, locomotor disability, mental retardation, and mental illness, leading to labeling tendencies. It lacks any penal provisions for the non-implementation of the law. The Rights of Persons with Disabilities Bill 2014 contain measures to be taken by appropriate government to protect disabled persons from violence, abuse, and exploitation. However, it fails in laying down clear provisions for access, support, and relief from the criminal justice system for the disabled. The Code of Criminal Procedure Code 1973 does not provide any mandatory method of recording of statements of people with disability. Criminal Law Amendment Act 2013 mandates videographing of a woman victim with disabilities statement in presence of an interpreter or a special educator in cases of rape, acid attack, sexual harassment, stalking, and the like. Minority groups and weaker sections of the society. Minority rights have gained greater visibility and relevance all over the world. India is no exception to it, being a multi-ethnic, multi-religious, multilinguistic, and multicultural society. Diversity of all types is very soul of India. United Nations Minorities Declaration of 1992 states, minorities as based on national or ethnic, cultural, religious, and linguistic identity, and provides that states should protect their existence. Due to the pluralistic nature of the Indian society, consisting of a large number of ethnic and religious groups, it is imperative for the criminal justice system to consider the constitutional goals of secularism, humanism, and common brotherhood. Criminal justice system should be very sensitive and careful in its approach to avoid communal bias in matters involving two or more communities. Since minorities are more vulnerable of being victimized, the criminal justice system should be very prompt and specially trained and equipped to deal with such cases. The National Commission for Minorities (NCM) was set up under the National Commission for Minorities Act 1992. Muslims, Christians, Sikhs, Buddhists, and Zoroastrians, that's Parsis, have been notified as minority communities by the Union government. Further, according to notification on 27th of January 2014, Jains have also been included within the group of notified minority communities. The commission comprises of one chairperson and 5 members representing the different communities. State minorities commissions have been set up in various states like Andhra Pradesh, Assam, Bihar, Chhattisgarh, Delhi, Jharkhand, Karnataka, Maharashtra, Madhya Pradesh, Manipur, Rajasthan, Tamil Nadu, Uttarakhand, Uttar Pradesh and West Bengal. These commissions function to safeguard and protect the interests of minorities. Aggrieved persons belonging to the minority communities may approach the National Commission for Minorities after exhausting all remedies available to them. Prevention of communal and targeted violence, access to justice and reparation Bill 2011 was drafted post Godhra riots to check riots taking place between majority and minorities. The bill provides for relief, reparation, restitution and compensation. The draft bill has faced acidic criticism on account of it itself being communal in nature in the garb of being anti-communal. Some of the criticisms are the provision of the bill tries to protect minority communities based on religion and language along with scheduled castes and scheduled tribes. In the opinion of the critics, it simply tries to target the majority in course of protecting the minority. It is said to curb freedom of expression by stating, notwithstanding anything contained in any other law for the time being in force, whoever publishes, communicates or disseminates by words either spoken or written or by signs or by visible representation or otherwise acts inciting hatred, causing clear and present danger of violence against a group or persons belonging to that group in general or specially, or disseminates or broadcasts any information or publishes or displays any advertisement or notice that could reasonably be construed to demonstrate an intention to promote or incite hatred or expose is likely to expose the group or persons belonging to that group to such hatred is said to be guilty of hate propaganda. Bill, if passed in the present form, will hit the federal structure of the country. Law and order is a part of the subject list, and if Centre frames legislation on this aspect, it will lead to an unconstitutional act and lead to regionalist tendencies subsequently. The offences under this law have been made to be non-bailable and cognizable, even if they are not so under IPC. To conclude, we can say that the approach of the society should not be merely sympathetic, but should rather be empathetic. It should be ensured that victims are given their due rights as a matter of right rather than on ex gratia basis. Legislative framework and policy should focus on the particular needs of such vulnerable groups and draft accordingly. Vulnerables of the society need our support and respect and do not deserve neglect and apathy. Thank you.